staff for being present today. We appreciate your time and for coming and being here. I think that takes us to roll call. Anna?
Amy Milstead, presiding officer.
Present.
Thomas Griffin.
Present.
Jimmy Zulke is absent. Kyle Jackson.
Present.
James Spears.
Present.
Tasha Mora.
Present.
Gary Hoffman.
Present.
Charles Rash.
Present.
And Ken Ulmer.
Present.
We're all here, ma'am. You have a quorum.
All right. Good morning to everyone. We're so glad that you're with us today. And those listening on YouTube, thank you all for participating. Your voice is important. All right. Looks like that will take us to the approval of minutes. Did everyone have a chance to read their minutes?
I'll make a motion to accept those minutes.
Thank you, Ken. Do you have a second?
I'll second.
Tasha Mora will second.
Okay, we have a motion and a second. Minutes are approved as written. Thank you all. Okay, that brings us
to do a roll call vote to approve the minutes.
Oh, I'm sorry. I got ahead of myself. Okay. Go ahead.
Thomas Griffin.
Aye.
Kyle Jackson.
Aye.
James Spears.
Aye.
Tasha Mora.
Aye.
Gary Hoffman.
Aye.
Charles Rash.
Aye.
Ken Ulmer.
Aye.
And presiding officer Amy Milstead.
Aye.
Motion passes.
Okay, now we're caught up. Sorry about that, guys. Okay, so that brings us to public comment. I believe we all got the note that we have no public comment request. Okay, all right, so I guess we move forward from there. Okay, all right, that takes us to staff reports. I believe we're going to start with Field Inspections Division. That would be Juan Munoz. Good morning, Juan.
Morning, everyone. My name is Juan Munoz. I'm with Field Inspections. I'm a region manager, and I will be doing a brief this morning. First thing we'd like to do a personal update here. Our division director, Tanya Guthrow, retired effective October 30th. Tanya began her career with TDLR 36 years ago as part of a part-time employee while attending the University of Texas here in Austin. Since then, Tanya has moved up the ranks with the agency. She leaves behind a legacy of great leadership, quiet strength, passion, and a wealth of knowledge within the entire agency. So we'd like to congratulate her, and we will miss her. We also have a promotion. Inspector Ramon Rodriguez accepted the position of Inspector 5 for the East Region, and that was effective November 1st. So we want to congratulate Ramon for that. Next, what I have here is the statistics currently for the month for this quarter. What you'll see there is we did 30 for September, and I did have an update on the inspection numbers since this report was due before we ran our performance measures. I do have an update on the inspections for October and November. In October, we did inspect 58 VSFs. And so far for the month of November, we have inspected 32 VSFs. So there's a couple updates there. And moving next to our next. I'm sorry, I thought that was a question. TDLR for current projects right now, what we have are TDLR has suspended inspections on March 17, 2020 in response to the COVID-19 pandemic. After distributing personal protective equipment and providing safety training to field staff, inspectors began to perform limited on-site inspections in June 2020. Not only are we operating under restrictions due to health and safety concerns, but we have a limited travel budget. In response to these concerns, we have successfully implemented a virtual inspection process for some barber and cosmetology inspections, and we are finalizing procedures to perform virtual vehicle storage facility inspections. We do expect to finalize and implement the virtual inspection process for some vehicle storage facilities in the near future. This concludes our report. Are there any questions I can answer for you?
Any questions for Mr. Juan? Okay, I have just two, and you may have gone over this, and I do apologize. The limited travel budget, is that due to the COVID that we're dealing with, or is there some other reason?
Right, there's that was an agency request that I believe with all the divisions that we kind of monitor our budget. We do have a pretty big travel budget normally, so we did limit ourselves to travel based on the recommendation from the executive.
Okay, for COVID or?
Yeah, it was COVID. Yes, it was COVID, all COVID related. Yes, ma'am.
Okay, perfect. And then I know you're talking about virtual inspections and you're talking about future ones for storage lots. How about towing? Do you see those going to virtual as well?
Well, currently we're not necessarily doing tow inspections on a regular basis. We haven't discussed that particular piece. We're still in the testing mode or gathering information mode for our VSFs. Once we identify how that's going to work, and there are several issues that we have with the virtual for VSFs. Until we identify and fix those, we won't be addressing the tows yet. The tow companies are a little more difficult, especially since they're not all in one location.
That was my concern. Okay.
Chair
I
Milstead.
do, Ken Ulmer here, and I do have just a couple of questions if you don't
Yes, sir.
mind.
No, sir.
And I know you haven't finalized everything on the virtual inspections for the vehicle storage facilities. One of the things as the TTSA chairman that I found is a lot of those storage facilities are very, very small operators and very minimal technology experience.
Yes, sir.
Are we taking that into account so that we can be sure that they're capable and have someone available? You know, we deal with a lot of these vehicle storage facilities that'll bring in a daughter or a granddaughter or something to help them with some of this technological stuff. And it seems like they struggle sometimes. So I want to make sure we're, addressing that issue so that they can handle meeting your expectations.
Yes, sir. And so we take that into consideration. That is part of our assessment of whether or not this is a possibility to continue with this process. We've currently done roughly 25 virtual inspections. Some of those have just been mocked to kind of test exactly the kind of issues that you're addressing. Sometimes it's a location based where maybe there's limited connectivity even through the cellular service that they may be using or through Wi-Fi potentially. So we have taken all of those things into consideration, and what we're continuing to address the pros and the cons of doing the virtual and identifying all the issues and concerns that we identify as we continue with these virtual inspections. So it's an ongoing process, and we're trying to be very deliberate to ensure that this is going to be a quality inspection that addresses all the requirements for inspections, and at the same time that we don't interrupt the normal daily operations of VSF as well.
Great. And I envisioned they would take photos of their signs and things like that to upload to you so you could see them.
Yes, sir. And there's part of it. And again, there's some of those things that they can do for us ahead of time, so we can maybe spend less time if we were, say, do partial virtual and partial on site. So we've taken some of that where we may do some kind of a hybrid, so to speak, inspection to eliminate the amount of time we spend there. So yeah, we've considered all of them. We've done different ways of sharing information, communicating and sending documents to each other, and we're addressing all those pros and cons to that.
Great. Let me say I commend you, and I welcome the opportunity to move into the future with things like this. Thanks.
Thank you, sir. We have a great team of folks who are working on that.
Presiding Officer Milstead. This is David Gonzalez, Deputy Executive Director of Licensing Services. I just wanted to assist Mr. Munoz. We also were challenged with the budget crunch because of COVID-19, and we had to have a 5% budget cut across the board. So that did affect some of our travel budget, along with some of our other positions. They got frozen for some of our programs. So I just want to make sure it's not just decisions made arbitrarily for TOED program. It actually had to do with some of the budget cuts in COVID-19.
Perfect. Thank you. Thank you both for the clarification. Anyone else have any questions on this topic? Okay, well, we definitely want to congratulate Tanya Guthrow. I know she's been a wealth of knowledge for the industry, and congratulate her, but also let her know we're going to miss her tremendously. We welcome the new leadership, and congratulations to Ramon. I know he'll be an asset to work with as well. So thank you, Juan. We appreciate your time this morning. Okay, that takes us to RPM. Todd Forrester, you're up, sir.
Good morning. Hope everybody can see me. I'm Todd Forrester with the Regulatory Program Management Division. We have some current projects ongoing. We are still conducting the trainings via Zoom. They've been going well. We had one yesterday, actually. It was we try to do it on the second Wednesday of every month. This month, because of Veterans Day, we changed it to yesterday. We even had some members from our advisory board there, Mr. Ulmer. We try to go through everything a VSF needs, the compliance manual, answer any questions anybody has. Along what Juan was saying about travel, it helps not only us, but also the industry from having to travel far. We're able to bring in more rural vehicle storage facilities who may not be able to travel to Dallas or Houston. So we feel like it's helping. I enjoy the format. We enjoy getting and talking to the industry and hearing your concerns and educating as best we can. We are still looking at our contacts, how many people contact us on both phone calls and emails. We are using that along with the web traffic from the industry compliance page to try to get a better understanding of what the industry may need as far as training or what kind of questions they have. If you could scroll down a little bit, Anna. We are still looking at a webinar-based training. I want to do it a little bit different. I want to get into more specifics. There's areas in the VSF rules that can be complicated in and of themselves, such as notification letters. If we could focus in on that, we do feel that it could greatly assist. Have a little shorter trainings, but a little more focused. We think it could help. Scroll down, Anna. Anna, scroll down, please. If we keep going, we are also looking at revamping our FAQs, our frequently asked questions. That is going to come about along with the rule. We're looking at the rules. We're also going to go in and look at the FAQs. That's going to provide us an opportunity to better explain our position on certain topics. If anybody has any suggestions on things they would like to see in the FAQs, please let us know. Let me know along with the rulemaking process. Are there any questions?
No questions on my end. Anybody else? As always, Todd, we thank you for everything you're doing in the industry. We appreciate all your hard work, you and your team, and thanks for being there. Thanks for all the training.
Thank you.
All right. I believe that's going to take us to enforcement. That would be Michael Shirk. We always look forward to his announcements.
Amy, are you hearing me?
I can hear you. Ken, did you have questions? I'm sorry.
Yeah, I got a text from someone that said that the YouTube channel is not getting audio. If someone could check that.
Okay, Anna, I guess that's taking care of behind the scenes.
Definitely. I'm going to text Michael Fickle. He's the host and webmaster that we have. And I'll let him know what's going on with our YouTube.
Great, thank you.
Perfect. Okay, Michael, back to you.
Thank you. Let me dive into this. There's quite a lot of materials. The numbers and statistics that you're going to be looking at are for the combined fiscal year 2020, which of course runs from September 1st, 2019 through August 1st, 2020. The first area is what we always do is the personnel updates, and you'll just note that Jackie Revilla has been promoted to prosecution legal assistant manager. Jackie has been here longer than I have, and it's been a joy working with her. I've seen her rise through the ranks, getting her stripes, you might say. She previously worked as a legal assistant when I got to work with her, and then as a senior legal assistant supervisor of the enforcement division. And it's great having her now in the position that Daryl Kuntz used to occupy. I know it's not listed here, but I did want to make all of you aware that I'm also going to be retiring. This is my last advisory board meeting, and I did want to share what an honor it has been to work with all of you, and just remind you of what an incredible staff you have here at TDLR, especially in the towing and VSF section. I've seen it become a much more efficient, effective, and analytical program than when I started here 5 years ago. And it's something you can all be proud of, the work that we do here at Tow VSF. So moving on to the statistics. These are enforcement performance measures and key statistics for the tow program. They speak for themselves. You see that we opened close to 1,800 cases in the fiscal year. We closed 1,600. So we're beginning to narrow the gap between the cases that come in, the cases we work, and the cases that we're able to close. We're still at about 200 days for the average length of close in a tow case. The VSF cases are a little bit faster just because it's easier to find people, locate documents, and acquire whatever information is necessary from the inspectors, the investigators, and the prosecutors to make swifter decisions to take quicker action. You see what we have at the very bottom of those statistics is something called cases pending. Cases pending are the total number of cases that are open right now. They may be with an investigator or a prosecutor. However, no formal action has been taken on them, such as the issuance of a notice of alleged violation or default order. It's just the total number of cases that now are awaiting formal action by a prosecutor. What's interesting, I think, in the pie charts at the bottom of the page is if you look at TOW and VSF, the complaints are primarily, overwhelmingly, driven by consumers, almost 3/4 of them, whereas in the average TDLR pie chart, it's less, not significantly less, but I think that reflects well on our ability to get complaints filed quickly and efficiently from TOW and VSF. Well, let's say vehicle operators or vehicle owners, get them into our system through our online complaint system and move them. The second largest component for TOW is a criminal history, where licenses are either revoked or denied because of criminal history. And one of the cases I'll be talking about is a criminal history case to make you more familiar with how that process works. And then, of course, the department is allowed to open and investigate cases where it itself has received information showing that a violation of the laws within our jurisdiction has taken place. And that changes. You can see a lot of those are from VSFs. That's, I think, a reflection of we have investigators who go and find the violations and then write up a report and forward it to prosecution. It's interesting, the case outcomes. We're still getting a good number of commission orders where cases go through the formal adversarial proceedings over at the State Office of Administrative Hearings. An administrative law judge makes a recommendation, and then the recommendation from the administrative law judge is taken to the full commission, and they vote on whether to adopt it, reject it, or adopt it with some modifications. So the commission is getting a fair number of cases from TOW VSF. The default orders are simply cases in which we have issued a notice of alleged violation. We request the respondent, whether it's a tow truck driver, a tow truck company, a VSF employee, or VSF, to reply, tell us why our accusations or alleged violations are factually inaccurate. We also offer them a settlement opportunity, or of course we also tell them that if they want to go to a formal contested case hearing at SOA, they can do that. For whatever reason, they choose not to respond, and then after the passage of about 60 days, and lots of notice to them that this will happen. It's not just the passage of time and all of a sudden a default order issues. When a notice of alleged violation has not been responded to within the requisite 30 days, then further notice will be sent to them that the matter is going to be set for default hearing if they don't respond. At that point, we get a lot of letters asking us to set the case for hearing or to go ahead and settle the case. And we're always in negotiations with people, even after we send the first notice of alleged violation, even after we send the notice of default. If our license holders and staff become to reasonable settlement negotiations, oftentimes involving restitution, the default orders will not go and commission orders won't be necessary. Agreed orders are exactly what they sound like, and you can see they are the overwhelming majority of what we receive is the agreed orders, where we all come to an agreement that there has been a violation of the law in some way, negotiate a little bit about what the penalty might be. The nice thing about an agreed order is you can get restitution, when sometimes if you go through formal proceedings, you can't get that. What's also an interesting phenomenon about agreed orders is people are much more likely to comply with their terms, not just paying the penalty, but also maybe taking a few extra continuing education hours or operating their business in a different way. So it's a real nice way for the department to work cooperatively with a licensee to maybe modify some behaviors as well as get restitution. And we also get administrative penalties, of course. And as I said, when somebody has agreed that they've engaged in an error, and we come to terms about what's its rate of settlement, the collection rate on those is much higher. The penalties assessed and what's actually collected still vary widely. We have different collection mechanisms, from referring cases to the Office of the Attorney General for collections, to us opening brand new cases against the respondents, going through the contested case hearing and revoking their license. Because when an order is issued, whether it's through a commission order, an agreed order, or a default order, the failure to comply is a violation of an order of the executive director, which is grounds for revocation of a license. And so those are three of the mechanisms that we have for trying to collect the penalties that we assess. In, I would say, maybe 15% of the cases, the people just go out of business. And at that point, we put an enforcement hold either on their individual license or on their company license, which prevents them from re-entering the business unless they square things out with us and pay whatever penalty has been assessed. Over the last year, we've only revoked 10 licenses because of disciplinary proceedings. We've suspended no licenses, so you can see we're not really out there to take people out of business. It's always been the department's philosophy and desire to work with businesses to ensure compliance rather than just throw the book and seek prosecution. It ensures that businesses remain solvent while also recognizing the legal responsibilities they have to consumers. Informally resolved cases reflect any cases that are closed without an order. Those include insufficient evidence. We get a lot of those where people are mad, they file a complaint with us, and there's just not evidence to support the allegations they make. They might receive a warning if this is somebody who has no history and the violation doesn't cause discernible consumer harm. We'll issue a warning letter. Oftentimes, we negotiate refunds if somebody is towed, without legal authority. Let's say the signs aren't posted, and they're towed. Rather than prosecuting the tow company, we might agree that they simply refund the consumer, and that's really a priority here, instead of collecting as many administrative penalties as we can to try to make our citizens whole from any wrongdoing that's happened. Also, informally resolved involves cases where the complaints are withdrawn, and that happens, I would say, in about 5% of our cases. What's interesting now is the next two pages deal with the alleged violations at opening, that is when the case first comes in through our intake process, and then the violations that actually result in disciplinary hearing. So you can see we get a lot of towing without authority. And again, that's people coming back to the parking lot, finding the car's not there and saying the tow company has violated some law. We get 380 of those. And if you look at the next page, you'll see that we actually took disciplinary action for tow without authority in 5 instances. People tend to get a little irate when their car disappears from the parking lot after they come back from the show. And I just thought that was an interesting comparison, the number that we get. Going back to page 2 of 6, criminal history is a big basis. People make complaints about the criminal histories of each other's, and they're not all the time well-founded. Overcharging for tows remains a big one. The two instances we see that is in municipalities that have caps on their towing rates. For instance, Houston, which has a $145.50 cap, and the tow companies try to charge it under their incident management tow fee schedule. And sometimes this is in good faith. You know, the tow driver sees a wreck happen, they tow it, and they believe it's a consent tow, and they charge whatever they want to. Sometimes they're just ignoring the local municipality and the fee caps. I think one of the most alarming statistics here is the number of unsafe and incompetent tows that happen. And that is always a result of, I wouldn't say it's lack of training. I wouldn't say it's because people are using drugs or anything sinister like that. I think it's because tow operators want to get a car up and loaded and away from the scene as quickly as possible. And then that oftentimes results in the vehicle not being properly strapped or being put on improperly so that it drags, or the dollies aren't used. It just, you know, the tow drivers are rushing so quickly to get the car away before the vehicle owner shows up that they cut corners. And we prosecute those very seriously because, as you know, towing is an ultra hazardous activity, and it's not just the drivers who are at risk, but also citizens driving on the roads if the car is not properly loaded. So those numbers speak for themselves. If you turn to the next page, 3 of 6, you can see the tow violations that actually resulted in disciplinary actions. Of course, we have the criminal history. What is, you know, the third one down on that list is lacking honesty, trustworthiness, and integrity, which we've seen that swell because of the flipping problem out in Harris County. And I think the word seems to be getting out that TDLR does not, will not tolerate that. The commission has been very forthright that even if it's a first violation and we've proven that there was a embedded systematic business practice to either take the car directly to an unregulated body shop by fraudulently inducing a signature from the vehicle owner, or transferring it from a VSF by fraudulently obtaining a signature from the vehicle owner to transfer the vehicle and to authorize repairs. We go for very stiff penalties the first time around. This is not where we just start off and say, okay, we're going to hope you learned your lesson. So those cases have escalated to almost a top priority for the department. I think those numbers they remain pretty consistent through the years, and they speak for themselves. I'm going to move now to the alleged violations for vehicle storage facilities. And again, the biggest one is failure to timely mail notice. A lot of times what happens is notice is sent to the vehicle owner, and the vehicle owner may or may not be at the same address, but we do carefully make sure that this information is timely sent to the vehicle owner, vehicle operator. And it's you know, one of the most important safeguards that our consumers have is to know where their vehicle is, how to recover it, you know, what hours, and also the first and second notice letter contain important information about vehicle owner rights, so that if you believe that the tow was illegal or overcharged, you can begin the whole process of going to the JP court and trying to get a refund. Unauthorized fees continue to be a problem where people slip in charges. In fact, one of them is in the case summaries that I've provided. What we see sometimes is a person will come in with let's say a VSF 11 form to release the car, and the vehicle storage facility will charge $5 for the notary fee, or they'll charge some money to jumpstart the car if the battery is dead. And then what we have is a very specific list of what a VSF can charge for, and everything else is prohibited. At the very bottom, you'll see that we had 27 allegations of unlicensed VSF operations. What is interesting on the following page is that there were no actual disciplinary actions taken for operation of an unlicensed vehicle storage facility. So I think if you have questions about those specific numbers, we can go back to those after I finish this case summary. But instead of me just reading them out to you, I think they speak for themselves. So what I did in the case highlight is I wanted to bring a number of different kinds of cases to your attention to see how and where we get our materials to then make a decision about prosecution. The first one is a default order, and it was issued assessing a $7,000 fine and a $25 order of restitution for making incident management tow and not taking it to a licensed vehicle storage facility. In fact, in this instance, the respondent, Mr. Garcia, lied to the vehicle owner about his inability to take it to the shop because he said the shop the repair shop that the vehicle owner wanted the car to go to was closed and they wouldn't accept vehicles. Along with that $5,000 administrative penalty for flipping the vehicle, that is taking it to an unregulated body shop through fraud and dishonesty levied against the vehicle owner. There were some other charges we threw in. Towing fee in excess of the cap imposed by Fort Bend, and also the failure to give a copy of the tow ticket to the vehicle owner. As I put in the last paragraph, we haven't collected any penalties on this individual, but his incident management tow operator's license expired on the 9th of November. He will not be able to renew it or get a new one until he makes things right with us in terms of not just the administrative penalty, but also the restitution to the consumer. And I think that's a very effective tool that we have in our efforts to try to collect more penalties, which is just simply not renewing people when they have outstanding penalties against them. Oftentimes in these cases, I would say upwards of 30% of the time, by the time somebody is engaged in this kind of conduct, they've decided maybe this is not the right business for them, and they just don't even try to get a new license. The next case is a criminal history case. And I kind of went into some detail in my written narrative because I don't handle these. We have a couple of specialized prosecutors who do the criminal history cases. But in this instance, the hearing, we advised the license holder that we were not going to renew based on his criminal history and his falsification of information on the license renewal. He asked for a hearing. You always get a hearing before you lose a license or denied a license with TDLR. The administrative law judge recommended denial of Mr. Beard's renewal because of his criminal history. And his criminal history is a little bit down the road. It was, on the next page. In 2017, he pled guilty and was in fact convicted of the misdemeanor offense of theft of property, which is theft of property between $750 and $2,500. It was just the nature of the property that he stole orange strobe lights from 2 vehicles while he was operating his tow truck. In addition, when his renewal application was being reviewed, on numerous occasions it was requested of him to explain why he had no criminal history on his application, and he never responded. Now, the department for every program has got what we call guidelines for license applicants with criminal convictions, and they vary based on the license type which is held. They generally consist of crimes that are directly related to occupations regulated by the commission. For tow operators, crimes against property are in those guidelines, giving us authority and jurisdiction to either not renew or to deny a license. So in this criminal history case, we believe that the theft of the strobe lights while he was operating a tow truck fell within the criminal conviction guidelines, warranting non-renewal. The administrative judge agreed. She issued her proposal for decision. The commission reviewed it and agreed that the criminal conviction made him unfit to hold a tow truck driver's license. He is able to reapply for a license in August of 2021, 1 year after the commission order. And at that time, the commission will take into account what rehabilitative efforts and whether or not basically you might say he's kept his nose clean and shown that he does not have or no longer has a propensity to steal, because as you know, tow truck drivers are always in a position to steal belongings from cars. The next case involves a VSF, which charged an administrative a $13.60 administrative penalty. That fits into our penalty guidelines as a Class B violation, and so the penalty that came out of that was $750 for overcharging $13.50. And I will just share with you that the cost of doing business honestly must always be less than the cost of doing business dishonestly. In our prosecutions, we serve two functions. One is specific deterrence to make sure that that individual does not do that conduct again, but general deterrence to send a message to the industry that unsophisticated, unknowledgeable consumers who are in a hurry to get their car back and have no knowledge of vehicle storage facility laws will simply not be cheated. And if they are cheated, there's significant penalties that will be imposed. This penalty was, by the way, paid in full. The next case comes to us. It's one of those ones we looked at earlier as department generated. This case came from a periodic department inspection. And I know I only deal with inspectors maybe 15% of the time, and I don't think they get enough credit for what happens at TDLR, going around and doing the dirty work of making sure that VSFs and tow companies are in compliance with their periodic inspections. In this case, looking through the files and the records, it was determined that the vehicle storage facility failed to send notification letters to the lien holder and to the vehicle owner, charged a $50 notice fee, despite the fact that the car, the notice letter was sent after the vehicle had been released, and failed to have legally required signs advising citizens of the methods by which they could recover their vehicles. That is to say, what the 12 instruments of release were that a vehicle owner could show in order to obtain repossession of their vehicle. And then the last case is also the last case also involves a periodic inspection, finding some violations, but this one came out in the form of an agreed order that it was found during a periodic inspection that there were 4 instances in which respondent failed to have vehicles available within 24 hours or available for release 24 hours a day, because they accepted vehicles 24 hours a day, so they had to be available for release 24 hours a day. And 2 instances in which it was found that the respondent failed to send second notification letters, and also failing to maintain records showing compliance with VSF employee drug testing requirements. In this case, the agreed order was issued for $2,700. That undoubtedly was a result of a negotiation, reducing it significantly from the penalties that could have been sought, and that penalty has been paid in full. That concludes my report, and I'm happy to answer any questions that anybody may have.
I have a couple, Michael, if I could. So a couple things. First of all, let me commend you on your work on the flipping issues. I think it's really having an effect on the industry, a positive effect.
Thank you.
So I commend you on all of those efforts. I also want to commend you on allowing the companies to correct minor violations. I think that's a very good step for the department. When those minor violations that didn't lead to a consumer being overcharged or taken advantage of, to allow them to correct that. So I really appreciate that. I was wondering, on the penalties assessed, I get a total dollar figure for tow and VSF and for TDLR. Is it possible to get a percentage of like the average of each one of those penalties in each one of those categories?
Well, the people in our analytics department are amazing. I'm sure it is. And so let me be very careful to write down what your request is to get an average sum of penalties.
Yeah, I like what you have here, but I would like to have the average per violation for tow, VSF, and TDLR as a whole. And my goal here, as you're aware, as a representative of the industry, I just want to make sure that our violations are in line with other violations or penalties charged and assessed are in line with what TDLR does with other groups and entities. Because that's really important to the industry. The industry constantly asks us questions and suggests that they are, in my training classes and meetings that we have, they suggest that we're penalized heavier than other industries. And I'd just like to have some documentation to say, no, we're not, or, this is the reason, to have some backup to when I get that answer, TDLR takes advantage of us or overcharges us on violations and penalties. I'd just like to have some data there to say, well, these are the numbers. I mean, they speak for themselves.
And I'll definitely put that in my notes from this meeting. I'll point out that, and I think some of the members of the advisory board participated in the rewrite of the penalty matrix for the enforcement plan for tow VSF.
Yes.
And we had heard for a long time the same complaint, that it was inequitable and overburdensome compared to other programs. And staff really took that into account and reduced, I would say, at least 50% of the violations to lower penalties. We had very, very good discussions in the work group about what the appropriate penalty class would be, and then submitted it to the commission. So I think that's something we've heard before and we've tried to address. I like your idea about trying to get the specific number for each one. It's hard to compare apples and oranges. What happens in massage as compared to an ultra hazardous activity such as towing. Oftentimes, there's not a one-to-one correlation. The other thing, Mr. Ulmer, that happened in our discussions in our rewrite of the penalty matrix for tow and VSF was we took away a couple of the higher classifications. Like I think we got rid of E and F, and which were the high classifications, and we gave prosecutors more discretion, so they had a range of penalties instead of being locked in. Because it used to be, if you had a violation, you were locked into a certain penalty amount, and that allows us then to also be more equitable in saying, is this a recidivist or is this somebody who just didn't understand the rules? Like Todd said, some of the rules are complex. So I'm sorry if I strayed, but I did want you to know that we've heard that before. We've, I think, in a very muscular way, tried to address it with members of the advisory board, and I'll definitely put in my notes your request.
And I have heard the same thing, and I want to reiterate, I feel like you guys have done a really good job of that. I just really would like to see those numbers as a way to show and prove when that question's brought up to us at a general meeting or a training meeting or something along those lines, to really have some data to say, look, these are the numbers. I mean, these are real numbers. You can go get them yourself and look at them. I had one other question about the case highlights. I noticed a $25 refund on the very first case. Was that all that the consumer was overcharged?
Yes. Yeah, the Fort Bend tow ordinance capped the fee at a certain amount, and I think what the tow company did was just charge a little extra for the town.
Okay.
We're not seeking a refund of the whole tow fee, just the excess charge.
Yeah, I was just curious. And there again, I mean, I really want to commend you on the flipping issue. That's something that has been near and dear to my heart, and I've worked on through my position in the automotive board in the city of Houston as well. And good job on that.
Thank you, sir.
Excellent questions, Ken. Thank you for touching on all of those. Any more questions from the board for Mr. Shirk?
I Tasha Moore, pardon me, do have a question, but I wanted to say, first of all, to Mr. Shirk, I wish you a very, very happy retirement, and thank you for everything that you've done for TDLR and all the information that you provided, and also bringing back deeper numbers and much more detailed numbers when you're asking for those in the report, that I've asked for that myself. So I just wanted to say thank you for the work, for doing that. The report that you brought today really does show that we were heard at the last meeting where we wanted more detailed information. And so I am still going back to the informally resolved. And what I think I heard, and just I want to make sure I'm clear, is under informally resolved, that would be cases where there perhaps there's no evidence of a violation, there's not sufficient evidence of a violation. Perhaps a warning letter was issued, negotiated refund, or a complaint had been withdrawn.
That's exactly right.
Perfect. Okay. So if the numbers that were closed, I'll use the tow complaints. The tow complaints that were closed were 1,035, and of those, 6.57 required disciplinary action. If no disciplinary action was required, does that mean that the rest of that balance of those complaints were informally resolved?
Ms. Moore, I'm so sorry. You're breaking up a little bit on the microphone. I've been pretty much able to follow you, but that last question, there's too much static.
And I'm hearing it as well. I'm not sure. I apologize if it's on my end. I tested it. It seemed to work. So my question is, of the cases, the tow cases that were closed, 1,035, of those 6.57 are the ones that require disciplinary action. And so the balance that did not require disciplinary action, would those be informally resolved?
Yes, I believe that that's absolutely correct.
That's it's actually good news for our industry to say that almost 93% were informally resolved. You know, I'm liking that we're able to see that number now. I'm curious as to how many, and perhaps this might be reports to come after your retirement, Mr. Shirk, but how many of the informally resolved were actually cases where there was no, or there was insufficient or not enough evidence to prove that there was a violation?
How many informally resolved arose out of insufficient evidence findings?
Right. It's just kind of what is that breakdown of those numbers? What I see is there's obviously a lot of complaints and a lot of closures, but many are resulting in informal resolutions. So I'm just curious what those numbers are, because it has an effect on the resources that TPLR spends on these cases. That has an effect on our industry as well. So how much correcting do we need to do with our industry, you know, in guidance and coaching? But also it's a reflection of having a vehicle towed is an emotional experience. And so some complaints could be emotionally driven, and how many are actual, there's no evidence of a violation. The service is provided true to the law. And I would like to be able to see some of that as well.
I want to just ensure that I understand what your request for data is, which is how many of the informally resolved cases are spring from insufficient evidence.
Yes, and much more pointed. So of the informally resolved, what is the breakdown of those that are for insufficient evidence or a warning letter, negotiated a refund? And I did hear that you said 5% the complaints were withdrawn. You gave that number. You reported that number.
Ms. Moore, thank you for the compliment about the detail of this report. I will tell you, I had very little input on it. It's our people in analytics who do this, Chris Russi and others who are simply amazing. I just try the cases. That's the easy work. I will make sure that my notes reflect that you've sought to learn of the informally resolved cases. How many of those are informally resolved because of insufficient evidence or warning, a negotiated refund? And I just got from Chris Rossi, I told you he was amazing, a text that said 513 of those cases were closed for insufficient evidence. So I think you'll probably see those numbers on the next report.
Probably, and I appreciate that. So everyone who's working on that, thank you.
Thank you all very much.
Yes.
Tasha, that's something that as well I was concerned about too. So I feel like a lot of people file a complaint, even though, you know, they clearly know they did something wrong, parked in a fire lane, you know, blocked a fire hydrant, things like that. I even get it on police tows quite frequently. And that's a concern. I would like to see as well, just like Tasha, how many of those complaints really had no merit. That's my goal, is to see how many of them had no merit, because I believe that a lot of complaints are filed that have a very little or no merit whatsoever. So I don't know how we can incorporate that in. I mean, maybe give it some thought, or maybe some way figure out a way that we could kind of determine that.
I agree.
Mr. Shirk, I have a question too. On the alleged violations and violations under tow violations, can you tell me what either examples or what might be talked about where it says charges not related to tow, what their violations are, what they were doing?
Let's see, what would they be doing if they did something not related to a tow? They may have charged fees that they didn't incur. They may have, you know, in order to charge fees for a tow, it has to be directly related. The conduct has to be directly related to the tow. We just had a case recently where the incident management non-consent tow fee schedule had lots of activities not related to tows, such as the hour of the day when the tow took place. The tows cost a different amount. There might be foul weather fees. There might be fees for the need to do a hookup. When we consider a hookup to be part of the tow, then it shouldn't be a separate fee. So oftentimes what you find is on the non-consent tow fee schedule, people slipping things in that aren't related to the tow. You know, they aren't directly, and that's one of the. I'll be honest with you. That's one of the very gray areas in the tow VSF regulations. Is what does related to the tow mean? But generally, you know, if everything is reasonable and necessary for the tow, but we do see instances where people try to bill for activity that's not directly related to tow, and again, that might be after hours fee. It might be we've had instances in the past where we actually had bad attitude fees. There might be catering fees. You know, food is brought to the site, but if it's reasonable and necessary and related to the tow and or the cleanup of the cargo, we're not going to prosecute that.
Okay, very good. The reason I was asking, this may or may not be related to it, and I don't know if you have the answer that I'm looking for on this. I had a customer of mine reach out to me just this past week, and he was a couple of counties over, and the sheriff pulled him over. They were driving a heavy haul load, and it doesn't happen. I mean, the loads are out there, but it doesn't happen very often. But the guy hauling the heavy haul load clipped a power line and broke a power pole and didn't realize that he broke it. He drove to the outskirts of town and parked it in an auction barn parking lot. The sheriff and 8 other deputies and city police showed up. They actually arrested him for fleeing the scene of an accident. So they called the tow company to impound his heavy haul load, oversized load, and the tow company drove it in, which happens on occasion at the request of the police. They separated the load at their location and parked the tractor inside, left the trailer and the load outside. they didn't actually tow the vehicle, and I think the customer has called in a complaint, but I'm sure nothing's happened with it this quick yet. How does TDLR view that when the tow company doesn't actually tow the vehicle and they charged $7,700 for basically driving in a tractor and trailer? So it's outrageous fees anyway, but I know they're in an unregulated area. So
Michael, this is Elizabeth, Salina Strip Manor. If I can jump in, I think that this may go into a possible complaint, and we probably should stay away from commenting directly on a possible complaint.
Okay. So say, for instance, my tow company had the same scenario. Are you allowed to charge for driving the vehicle in, or do we look at that as, how does TDLR view that? Should there be any charges, or there's no tow charges since the vehicle is not actually towed in?
Well, no, you can't charge tow fees if you don't tow the vehicle, which means mechanically strap it to a tow truck and move it. What you're saying is that they just got in the tractor and drove it?
At the direction of the county sheriff, correct. The sheriff told them to impound it, and this is like a 180,000 pound load. There's no way to.
Mr. Hoffman, I'm sorry, Mary Winston to TDLR. Very good questions. Michael is giving you very good answers. However, we are going to kind of cut this discussion a little short because for a couple of reasons. One of the reasons is we have to give notice of what we are going to discuss. And we have case highlights of cases that are within the report, so forth and so on. There are some interesting scenarios that you've brought up, and the complaint that you've told us about is relatively new, and we wouldn't have any information on it right now, nor would it be discussed during the advisory board meeting. But if you have some specific questions, you can, of course, send those to advisory.boards. We'll see what we can do about that. But we just don't want to stray so far off. No, yeah, okay. So, and you're in good hands. You're in good hands. You're in good hands.
All right.
Okay.
Thank you all very much.
And congratulations on your retirement.
Thank you.
Okay, I think that is all the questions that we're going to take today. Again, Michael, we thank you for everything you've done in the industry. I know you're going to be terribly missed, but we welcome Jackie. I know that she's going to be an asset to the department or to the group as well. I can't thank the board members enough for their questions. It's so nice to see active new board members and the collaboration that we have. You guys are great asking all the questions that I know some of us are thinking and we hadn't worded it or hadn't got it out yet. So thank you guys for that and all your input. Okay. And a question that I have, and this is probably for staff more so, when was the last time we reviewed the penalty matrix? And is it time to start looking at that again? I know I was involved in that in the past, and that's always something that's near and dear to our wallets.
So Mary Winston here, TDLR. I am not sure. We can look back on the last penalty matrix review. We know we have legislative session coming up, and when changes like that occur, if changes occur, we typically have a review after that time. So we'll look and make sure when the last one was. We kind of do it pretty often in this program for obvious reasons, and we have tried to clean up, make more fair. We've eliminated different levels of ENF. So, Michael, I don't know if you have the date of the last review, but I know with legislative session pending, it would be after that time.
I believe, Mary, this is Elizabeth. I believe the most recent review was in 2018.
Okay, so this would be right on time, so to speak, after session. So, and Elizabeth would be, as the general counsel for this program, she's going to be up on when that was. So yeah, definitely after. It may be timely, and we do have new members, Presiding Officer Milstead. So this would be a great deep dive for them to kind of see how that whole process works and the value of their membership in the advisory board for that. So after session.
Excellent. Thank you, ladies, for that. That's great. Yeah, that's very important, and I look forward to that. We'll keep it on our radar for sure. Okay, I guess the next report we have is education and examination. Michael Strawn, I believe, is with us for that today.
Good morning, members. My name is Michael Strawn. I'm one of the managers for the Education and Examination Division. Here to give you our statistics for this current reporting period. If you'll see that in September, we had 2 continuing education courses that were approved. That seems to be in line with our monthly totals that we average every year. So pretty much on par there. Additionally, we do not have any new curriculum for the training programs, which we've been consistent at for quite some time. That's all the statistics I have for you all, but I'm open for any questions that you have at this time.
Board members, no questions out there? Michael, short and sweet. Thank you. We appreciate your time.
Yep.
Okay, moving right along to Customer Service Division. Ms. Jacqueline Rush, I believe, is here.
Hi, good morning, board members. This is Jacqueline Rush with the Customer Service Division. You've got the statistics for fiscal year 2020 and September of this year in front of you in terms of how many calls and emails we've received for your industry. If you look closely at the numbers, you'll see that there is a dip in the emails that we received that started in February and then more so in March to the present. That is because we have programmed emails that come in with attachments to go straight to the licensing team so that they aren't bottlenecked in customer service. Other than that, the phone calls, even through the COVID period, seem to fluctuate somewhat, but the calls that we receive tend to be about getting application instructions for new tow companies, for the operator license, folks checking on status to see what they might be missing on their application. So we'll help them with pinpointing what it is they need in order to get their application processed. If they get stuck along the way and we're not able to figure that out, we'll quickly coordinate a call back from the actual licensing team, and they're really great about getting back to the customers. We also take credit card payments for renewals for tow operators and VSF employees, vehicle storage facility employees. And so that tends to be what our calls are about, like the top 3 calls that we get. And I'll be happy to take any questions.
No questions from the board? Okay, Jacqueline, thank you for your time. We appreciate your report.
Thank you. Have a good rest of your day.
You as well. Okay, Licensing Division, Laura Hernandez.
Good morning, board members. Showing is the personnel updates. Our staff is still working from home. We have a team member going into the office daily to help assist in loading work so that we can all work from home. The statistics provided are for fiscal year 2019-2020, which are the same statistics that I provided in our last board advisory meeting. Toward the bottom, the active tow company and tow truck population numbers. That one is updated as of November 2nd. It has the tow companies and the tow trucks listed in the order of the type of towing, the consent, private property, or incident management. And then the vehicle storage facility numbers are for fiscal year 2019 and 2020. We are working on providing the statistics for the number of emails that come into our area. Now that those emails are routed directly to us, to my team, to handle directly, we are working on a way for all programs so that we can report how many emails we're actually getting just for the team. Since that's no longer reported in customer service. So we're working on how we can get those numbers. And that's my report. If you all have any questions, please feel free to ask.
Any questions from the board? Okay, Laura, thank you very much for your report. We appreciate you. Okay, and last but not least, Executive Office Report, Ms. Mary Winston. We look forward to hearing what you have to say.
Good morning, board members. Thank you all for being here today. Starting off, I want to talk about our first item, COVID-19 response and the update. I began the last meeting bragging, and it was clearly bragging, about our IT, especially division and how swiftly they moved. But I also today want to add to that, really all of our staff. As Laura just said, though most of the teams are working remotely, we have in-office staff members who come in and who alternate to make sure that the work gets done. So the action of IT led by our executive staff was definitely swift, vigorous. It put us in a place that we could work virtually. We could work from our homes. There were transfers of computers and software and all these things that, we're the government and we move more like a barge versus a little, speedboat. But it's because we have a lot of heavy lifting, much like your tow trucks, right? Depends on the size of what you're lifting and how careful you have to be lifting it. But I must say they did a fantastic job in doing so. So our response has been it's been internal, external, and we continue with that. As you know, day to day, numbers ebb, numbers flow. And we have had staff members who have been affected by the pandemic, staff member families who've been affected by the pandemic. We've had to sanitize offices or floors or certain things. And what we do is we shift those folks somewhere else where they can work more safely. And we still provide updates. As we get information in, we try to dispense that information to our licensees and our stakeholders. So the update is that we continually do that. We are day by day as things change. And as we're all crossing our fingers, saying prayers for our vaccine to come to where we can all see each other in person again, we're working in spite of, and we're getting better. We still have different blips during the time of the virtual meetings, but they become fewer as we've all gotten more accustomed to and have been trained more on doing these things. So we are looking at steps on reentry into our office at a larger number, but we have not finalized that because Christmas holidays are coming up, and I always skip Thanksgiving, though I love Thanksgiving. We're around 20% in the office, and we'll go from there. But we're moving slow and steady, and we're getting the work done wherever we are. Legislative appropriation requests. Last time we talked about strategic planning and how we go out to the state and how we ask, what can we do better? What would you like to do if you were king or queen for a day and you ran this agency in this state for your program? What would you like to do? We take those things and then we develop strategic initiatives. And with those strategic initiatives, we then go into ask for funds to develop the things that we've asked for. So we go then to the legislative appropriation requests. This is filed with the governor's office and the legislative budget board several months after the strategic plan. And it is the fiscal document that is more specific on what we need to actually accomplish the goals and the strategic plans that we have put forth. It's an in-depth document. It's good reading, but it's a lot of numbers. So if you're not into that, take your time. It's on our website. On our first page, you'll see all of our reports. Just go into the reports and you can read that document, and it gives you an idea of what TDLR has asked for. We have, and why. Strategic planning, why are we asking? Legislative appropriation requests, what monies do we need to request to actually get those things done? We've spoken many times about the Texas licensing system, to get our licensing system to have one that is not expanded over 9 different systems, which is expensive, and it is definitely not cost effective for our staff to have to learn different systems and cross system. So we have requests related to that and different things internally that the agency does need to accomplish. Sunset Commission review process update. The update is that we still haven't had a hearing. You can still make comments on the Sunset Commission webpage, and we're anticipating a hearing coming up. But just like we've had to move to this different format, this different way of communicating, Sunset has too. And they've held other hearings. We're in line, but they have not gotten to TDLR yet. Please stay tuned. We'll give you notice as soon as we know of a date. We anticipate it will be virtual. I do believe the last one they did was both virtual and in person. Not sure if they're going to follow that format, but we will update you when we have more information on that. Finally, the communication outreach statistics. Anna, do you have a copy of those? And it's coming up. As you know, this is a snapshot of who's contacting us in your program for tow truck operators, for VSF facilities. An average view here of over 1,000 a day. 35% assess it from the desktop, 64% from a smartphone, and 1% from a tablet. That may seem to be an odd fact to kind of gather here, but as we move forth with technology, it lets us know, do we need an app? Is that something we need to start developing? Not putting pressure on our IT folks out there, but it lets us know the direction that our licensees are moving in and what we need to do to best accommodate it. Top reasons for visiting the site: consumer information about towing, how to apply for a tow operator license, vehicle towing and booting law, towing administrative rules, and vehicle storage facility administrative rules. So just that knowledge base of what they're looking for, and pretty standard. And I think this is a pretty good average of number of folks who visit the site a day. And it lets us know that we do have information that's helpful for those of our licensees and our stakeholders. If anyone has any questions, I'll be happy to take them at this time.
An app would be so exciting. That sounds wonderful.
I probably shouldn't have said that, but
we can wish, right? We can wish. Yeah. It is nice to see them visiting the site, and y'all over the years have made it easier for people to go to and find what they need to. So that's wonderful for our industry. I know we all can use that. We appreciate that.
I do have
questions?
one question, Mary, and I'm not sure if I'm directing it at the right place. As a VSF that has multiple towing companies that store vehicles with me, I'm constantly going to the site to determine and verify that their TDLR is up to date. And one of the things that I notice is when I go to the actual company, I can type in their TDLR number, I can pull up their certificate, but it doesn't tell me, it just says active. It doesn't tell me when it expires. And in order to see when it expires, I have to click vehicles and then pull up their vehicle record. And then on the right side of that, it'll tell me the expiration date. So is it possible, a lot of people don't realize to do that. They don't see that little tab at the bottom that says vehicles, insurance, and all those types of things. I think those are good tabs because it tells me a history, if they've renewed it or something like that. But would it be possible for us to be able to print a actual, like their certificate of registration would tell an expiration date? And that way we would be able to just have that document to know that that company is up to date.
Mr. Omer, that is a question that I will ask our IT folks. Even the question about the number of clicks, because a lot of times the end user wants as fewer as clicks as possible, right? But as you've said, it's all good information. So I have written this question down, and then we, of course, have this live video that will be recorded. Let me see. Let me get back to you. I'm not sure, but I can definitely look into that. I do see the need.
The other problem that we have on a frequent basis is knowing some information on that truck. So I'll have a towing company come to me that has 10 trucks. And even if I print up their vehicle record, it doesn't give me enough truck information to compare it to the truck that I'm trying to verify that they have licensed. So I'm trying to, meet my licensing requirement, and I have to rely on that company to tell me the right plate numbers and the right VIN. Even if we just had maybe the last 4 of the VIN number of that truck, not an entire VIN, we would be able then to match it up to what they presented to us and said, hey, these trucks are going to be bringing you vehicles, non-consent tows. That way I would know for sure that that truck was a licensed truck and not one of their trucks that say, like right now we have a lot of companies taking their trucks off of insurance because of the costs involved in COVID-19 issues. So we really are trying to stay on top of it to make sure that they're using the right trucks and that we don't have some mess up, even inadvertently, maybe not even their fault, or maybe they weren't intentionally doing it, but they may have taken a truck off their insurance and we wouldn't know.
Let me have some conversations internally to see what we can do, if we can provide that information more readily on the website. And it looks like you're saying if there's like 10 trucks, and it's quite possible, that's something you can't readily access from the website, and you'd be interested in having that information.
Right. I can see the 10 trucks, but I can't tell which truck is which. So if I had the last 4 of the VIN, I would be able to match that up, because we're required to report to the consumer the tow company's TDLR number. That's easy to obtain. But then we're required to tell them the license plate number of the tow truck that stored that vehicle with us, brought that vehicle in, because a company could have multiple trucks. Some may be IM, some may be consent, some may be private property. So we just want to make sure that we are logging that information correctly, and that the, and there again, it's inadvertently usually, but the tow company is not accidentally doing a IM tow with a consent truck.
One question, I'm not going to dive too deeply because I don't want to get off too much into other things today, but do they have cab cards?
Yes. So we request that cab card initially from the company when they begin to store with us, but we continually check it and update it to make sure the company hasn't had, their license defaulted for some reason or something along those lines, or maybe they took trucks off. So we have to continually check that and update our records. We've developed a way to do it through the city of Houston electronically, so we can electronically update it, but we're still doing it manually with TDLR, which I'm okay with, but I'd just like to have a little more information so I can actually be for sure that I'm matching up the right truck.
Okay, you've given me some homework. I love homework. Thank you, Mr. Ulmer. I'll look into that. And thanks for letting me know that City of Houston does have some methodology to do this. So let me look into it.
Great. Thank you very much. I appreciate you being so receptive.
No problem.
Thanks for your concerns, Ken. We appreciate that. Anyone else with questions for Ms. Winston?
I do. Tasha Mora. I see that. I love the breakdown that you can see so much information as far as like where those who are contacting the department, if they're using desktop or their phones or a tablet. Is it possible to ask on the back end of the IT group or whoever you would ask, is for consumer complaints, is that same information available as far as like, are they coming in through desktop? Is it phone and such? Just because it's kind of, it's good information to have. And I mean, there might be other versions as well. Someone might actually fill out a hard copy and submit it by mail, I would imagine. But my question is that same information available regarding the consumer complaints?
Tasha, I'm not going to say 100% yes, but I think it is. So Chris Russi, I don't see Mary Winston TDLR. I don't see Chris Russi on the screen, but I know he's listening in. So that's another addition that we can probably get on that enforcement report. So yeah, you just want to know how complaints are coming in.
Right.
Consumer complaints are coming in. Okay.
Right.
All right.
Thank you.
Any more questions? Okay. Thank you again, Mary. We appreciate everything you bring to us.
Thank you.
Okay. That moves us to agenda item F. And this one, I believe, is going to have Elizabeth Salinas Strittmatter for us. Discussion and possible recommendation on the proposed amendments to an existing rule. I think we all know this is referred to flipping. The proposed amendments explicitly prohibit tow truck companies and tow truck operators from towing vehicles involved in non-consent tows to locations other than those stated in the rule. Also recommending that vehicles be towed to any location other than a licensed vehicle storage facility. And 3, obtaining authorization from vehicle operators for repairs or any fees other than those required to perform. Elizabeth, I think you have a lot for us on this.
Good morning, everyone. I'd like to thank everyone for being here today. This is a very important day, I think, for the agency and for the industry. The long-awaited rule on flipping has finally become a reality. And I just want to give our new board members some background on this. For the past 2.5, 3 years or so, enforcement has been actively concerned and pursuing the rising tide of flipping in the industry. And for those who are not familiar, flipping is essentially when a vehicle is involved in an incident management tow, and that vehicle is then towed to a location other than a licensed vehicle storage facility. It's usually an unregulated body shop. This is a nationwide problem, which has resulted in millions of dollars in losses for insurance companies and also for consumers. So this is an issue that came to our attention because it was something that a lot of states, including Texas, were beginning to see as a growing problem. So you've seen Michael over the last couple of meetings, if you're new, and over the last few years, consistently talking about flipping cases in his enforcement reports. And there was a discussion last year prior to the pandemic. I believe it was maybe a few meetings into 2018, where members of the board started asking whether we could look into a rule that may help us to stem some of this behavior, and that would also help the industry to become more proactive in addressing an issue that has obviously become a problem for licensees as well as for consumers. We then went into sunset, and in May, the initial report issued by Sunset also requested that TDLR look into this question of whether we could bring forth a rule that would address the problem. So we began exploring that, and if Anna will put up a copy of Chapter 86 in our proposed draft rule. What we normally do for those who are new is I will go through the rule line by line, and then we will have a full discussion if anybody has any questions or concerns about the rule. What we are doing right now is we are proposing a draft rule. At the end, if someone would like to make a motion to adopt that rule, you may do that. If somebody would like to make a motion for word changes, you may do that as well. So feel free. This is now the time to ask any questions or concerns. Todd Forrester will be available to help if I don't know the answer to any questions, and Michael Shirk as well can chime in. But we're here to address, because what we want to do is we want to create a rule that is comprehensive and that makes sense for the industry, for TDLR, and for our consumers. So in looking at where we could put a rule, the first question that we looked at was, do we actually need to draft a rule from scratch, or can we amend a current rule? So we decided that we could amend a current rule, and that is 86-700, which is the responsibilities of tow truck permit holders, storage of towed vehicles. One of the things that we wanted to address from the very beginning, if you have been listening to Michael over the past couple of meetings in his reports, he talks quite a lot about not only flipping being an issue in and of itself, but also the issue of tow truck operators and tow truck companies, permit holders, being able to, having a rule that addresses both, so that we can have a robust and a full rule that is applicable to all tow license holders. So one of the things that we did here is that we expanded this rule to be applicable not just to tow truck permit holders, but also to tow truck operators. So we encompass the full licensee population. So what we did here is we have struck the original A. You'll see that down below on the 4th paragraph. That is anything in strike through is original language. Anything that you see underlined is new language. So what we did was we took A, we struck through it completely, and we rewrote it. And this is how we rewrote it. A towing company or tow operator that performs an incident management or non-consent tow may only tow the vehicle to one of the following locations. Now, if you notice, we have made sure that this rule addresses not just incident management, but also non-consent tows, because we wanted to make sure, again, that we are reaching the full possibilities of who this is applicable to and when it is applicable to. If we're going to go in and amend a rule, if we're going to go in and clarify a rule, we want to make sure that we are clarifying it to as wide of an expanse as we can possibly do it. So that is why we wrote this first line the first way, to make sure that everyone is on the same page, that an incident management tow is a form of non-consent tow, but we are talking about both incident management tows specifically and non-consent tows as a whole. So they may only tow the vehicle to one of the following locations: a VSF operated by a person who holds a VSF license issued by the department, which is not that much different than what the current rule reads, or a location other than a licensed vehicle storage facility licensed by the department that is specifically requested and authorized by the vehicle owner or operator, and to which a towing company or tow operator agrees to take the vehicle. That language in principle is not that much different than what the current language reads, but we have separated out to clarify the situations that we are talking about and where exactly these vehicles need to be taken. So then we get to B, which is an entirely new concept. Neither a towing company nor a tow truck operator may recommend or solicit authorization for a vehicle involved in an incident management tow or non-consent tow to be towed or moved to any location other than a vehicle storage facility licensed by the department. B gets to this, the heart of the matter here, and what happens in flipping, and the real problem we're trying to address is that we are trying to make it explicitly clear that there cannot be any recommendations by the tow companies or the tow truck operators on where to take these cars to, other than a licensed vehicle storage facility. We're trying to cut off the manner in which they are getting these consumers to agree to take these vehicles to unlicensed facilities without the consumer being aware that that's not really something that's supposed to be happening. So then in C, we say the event that the vehicle is taken to a location other than a licensed vehicle storage facility. That is, if the consumer wants it taken to a vehicle to a location other than a licensed vehicle storage facility, the authorization for the tow must not include authorization for repairs of any services other than those necessary to perform the tow. So what we're trying to get at here is the problem that we've been seeing, where consumers are inadvertently and not being aware that they are signing work order authorizations, which would allow an unregulated entity to begin tearing down their car without them really being aware of what they're signing. So we are trying to make it very clear that the only thing that those consumers must have put in front of them is what is necessary to perform that tow. That is what those consumers are signing for. Now, we also wanted to make sure, because we have in 2 the option that a consumer can say to a tow truck driver, I want my car taken to whatever dealership. And we wanted for the consumer to be empowered, but also for our licensees to be empowered, because they should not have a responsibility to take a car somewhere that is 100 miles away, 80 miles away, 300 miles away. So what we have done, as you will see here in 2, we have put in explicit language that says, and to which a towing company or tow operator agrees to take the vehicle. So there has to be a request by the consumer that is made by the consumer on their own, and an agreement by the tow company or the tow operator to take the vehicle. And so D kind of wraps this all up in a bow and says a towing company or truck operator may decline to take a vehicle to a location specifically requested and authorized by the vehicle owner or operator. We want to empower our folks to be able to say, I can't do that. That's not realistic for me to do, or simply, I just don't want to do that. But if the towing company or tow operator declines per the rule, they may not take the vehicle to any location other than the licensed VSF as set forth in A1. So we are reiterating in D that the tow truck operator has the ability to refuse, but if they refuse to take it to a place authorized or requested by the consumer, the only other option is to take it to a licensed vehicle storage facility. There is no other location that it can be taken to. And again, we're trying to get to trying to stop at the source this problem of these vehicles being taken to unregulated body shops, and our consumers not realizing that if they're going to go to an unregulated body shop, there's nothing that TDLR can do in terms of fees and the rules that are applied to our licensed locations. And we want our licensed locations to have the ability to receive the business that of these IM tows. So that is how we structured this rule, by basically rewriting it, reimagining it, and giving it a balance between consumer awareness and consumer protection and licensee awareness and licensee protection. We want both parties to be protected during this transaction, and we want our licensees to feel as if this rule does not set on them any higher standards than they had before, but rather clarifies what the expectations and the requirements are. So with that, we will open it up to discussion. And this is the time, as I said at the beginning, to ask any questions. If you want to make any motions for alternative language, this also would be the time to do that. So I will turn it over to Amy.
So much to think about here. First question is, Anna, can we get a copy of this after the meeting? Would that be possible? Okay.
Of course.
And then if you're just as eager as I am here, chime in.
Yeah, I am. I have, first of all, thank you for making this effort. This is something that, as my position in the chairman of the automotive board, I've been working on for a very long time. And I think you have really keyed in on some really key important parts. My concern is that, and I'm familiar with several of the cases that Mr. Shirk has dealt with because they were in the Harris County area. Most of those facilities had a licensed VSF, and they were utilizing that licensed VSF to direct those cars to a body shop that's connected. In almost all those cases, including the worst ones, that was the situation that was occurring. So it was very hard for you to draw that line. I mean, we've struggled with this at the city of Houston for the last 12 or 13 years, and the problem's only gotten worse and worse, even with a very highly publicized prosecution and a good outcome for the consumer here in Houston. So how do we address that? When that vehicle storage facility is located on the same premises as that body shop and they are fully licensed, how do we address that part of that situation that's going on?
I just saw Michael pop up. So you might want to address this.
Mr. Olmer, that is a very significant problem. It's a separate set of regulations if the board wants to take it up with respect to vehicle storage facilities. Because you're absolutely right. The vehicle storage facility is often on the same property that the body shop is on. And I can name a few names and you know who that was. And people go into what they think is the vehicle storage facility. The members actually employees from the body shop. The body shop employees divert them away from the VSF employees. Tell them all sorts of things about how they're going to. So I know the problem you're talking about with the transfer of vehicles from a VSF to a body shop. This one addresses what we see as the most immediate issue, which is when somebody's broken down on the side of the road after a wreck. You've got the sirens going on, the traffic coming by, maybe people are hurt. The tow truck driver walks up to the citizen and says, "Where do you want your car to go?" And the citizen says, "I don't know." And he'll say, "Well, I've got a real sweet body shop that my cousin owns." So this is definitely a first step. I agree with you that if that problem needs to be addressed by further regulations, I encourage you to keep that fire burning, because transfer from VSFs to body shops is, and the problem with that then is they have the VSF 11, which is oftentimes fraudulently notarized to create a very clean paper trail. Once again, showing that the consumer knew what they were doing under circumstances not nearly as traumatic as the circumstances at an accident scene.
And so just to tack on to what Mike is absolutely right. So what we need to keep in mind is that the rule amendment that we're talking about now relates to our tow licensees. If we need to do some companion rules in relation to the VSFs, we could certainly do that. Right now, our focus has been stopping the problem where it starts. But obviously that's not the only place. You're 100% right. That is not the only place where there are problems. And so we can certainly look at the VSF rules and to see if that is a place where we can make or should make some changes. But because the board asked us to focus on this group of licensees, and also Sunset asked us to focus on that, that is what we have focused on first as our first step. So keep in mind that when we pass a rule, that's not the be all end all of it all. If there does need to be some examination of where else in the companion licensee area, such as the VSFs, where else rules need to be made, we can certainly do that. This rule doesn't cut off that. But right now we are confining our focus to the tow licensee base. And if we need to expand that to the VSF base, we can do that later in a different rule.
Okay, so Elizabeth, just to make sure, and there again, I commend you guys for tackling this, because it is a very, very tough issue. A big part of the problem, as you know, body shops are not regulated. So,
yes,
you know, that is in itself part of the problem. Your wording on getting a document signed, I just want to make sure that it's clear enough that they don't use a different document, because in a lot of cases, the towing company will actually carry those repair orders in their truck. So is that language clear enough to make sure they don't use a different document, not the actual towing document, to do that authorization? The wording was just, there again, it's not on the screen anymore, but as I read it, I immediately thought, are we leaving a loophole there?
Let's go back and look at that rule. If Anna can put that back up, but I can read it to you. That would be the new C in the amended rule, and the new C would say, in the event the vehicle is taken to a location other than a licensed vehicle storage facility, the authorization for the tow may not include authorization for repairs or any other services other than those necessary to perform the tow. I don't think that we have left a loophole, but if you all do, you are certainly welcome to propose some alternative or additional language if you feel like that needs to be clarified.
So my problem is, it says the tow must not include authorization for repairs. So they would have a tow ticket that didn't include authorization for any other repairs.
Sure.
In our previous language, it said they could not get, I don't remember exactly the wording, but it basically prohibited them from authorizing anything else.
That's right.
That tow.
That's right. So if you wanted to make a motion, we could clarify that wording to change it to the tow ticket must not include authorization for repairs or any other services other than those necessary to perform the tow. If you think, and I think that you're probably right, that the addition of the word ticket, the tow ticket, makes it clear what document we're talking about. I think that would be a reasonable addition to make, but you would have to propose that.
I actually think the wording needs to go a little further and say that the tow truck operator may not obtain authorization in any form, meaning they can't have a repair order in their truck for a body shop that's not related to their towing company, or that's the claim, and get those repairs signed at the scene. Because then clearly in a complaint, when the consumer said, oh, the tow truck operator gave me a form right there in the tow truck and said, sign right here and they'll take care of it. That's my concern, is that the tow truck company is going to look at that, especially if we put the word ticket, and say, well, my tow ticket doesn't contain any of those things. But this other form that the body shop gave me and told me they would pay me a reward if I got it signed. We actually have a towing company right now, and I have a consumer just here recently where the consumer was taken to the body shop, and the towing company is paid a reward for bringing the consumer to the body shop with them to get all these papers signed away from the tow truck. So they've already seen this loophole, and they're already attempting to cover it.
Yes, and we're aware of the bounty situation. Michael has talked about that, I think, extensively when he's presented. I see he popped up and unmuted himself, so I think he might want to make a comment.
Okay.
You're on mute, Michael. You just muted yourself. There you go.
Ken, your comment is very true, and that was the workaround, because I think it said a tow ticket may not authorize, and so they would have the person sign the tow ticket, and then they would sign the authorization. But I think that the language prohibiting the recommendation or solicitation authorization to be towed to any other location addresses that concern.
Okay. I didn't tie it back into that, but yeah, you're right. Okay. Okay.
Now, if you want it, so Michael's absolutely right. He makes a good point. This rule has to be read in harmony. The parts have to be read in harmony with each other, because enforcement and TDLR will look at the totality of the rule, right? And so do our licensees. So even though C may not directly address what you're saying, D does. And so when you read them in harmony, I don't think there's any loophole. But again, you may want to add ticket behind tow to clarify that it is the tow ticket that we're talking about. And then B loops up to make sure that we aren't getting any other documentation signed, which would cause other things to happen, like a transfer over to an unregulated body shop.
Would it be possible in C to refer back to the section that Michael is referring to? Possibly to say, I mean, because this is what's going to happen. They're going to specifically read that. And I've even seen agencies who regulate us do the same thing. They're going to refer specifically to C and go, well, it was a different paper, so he's okay.
I don't know that we need a citation to B and C. We may need an and rather than that. So if we were to put the word and in after B, it would read, neither a towing company nor a tow operator may recommend or solicit authorization for a vehicle involved in an incident management or non-consent tow to be towed or moved to any location other than a vehicle storage facility licensed by the department. And in the event the vehicle is taken to a location other than a licensed vehicle storage facility, the authorization for the tow ticket must not include authorization for repairs or any services other than those necessary to perform the consent tow. That way it is clear that B and C are connected and are to be read in harmony.
Elizabeth, that does exactly what I wanted to do.
Okay,
exactly.
We can do that. No problem.
And I will make the motion to include the word ticket after tow in C.
And we would also need a motion to, well, I think we could do a motion at the very, I don't know how Amy wants to do it. If she wants to go through and see if anybody else has any suggestions on language and do it all at once, or if she wants to do it piece by piece. How would you like to do it, Amy?
Yeah, I'm sorry.
I think we go through the rest of the discussion, because I know I have something to add and there may be others out there. So
okay, that's fine.
Okay, Ken, are you good? You got more? Or can I
yes, no, I'm good.
Okay, my concern is going to the tow truck operator towards the bottom may decline to take it to their request, or tow operator may decline to take the vehicle to a location specifically requested. I know this whole flipping process is about the bounties that are being paid to the collision centers. I'm very well attuned to all of this. My concern is if the tow truck operator or the company has the right to refuse to take it where they want to go, this to me is a stall tactic. They are going to take it to the licensed VSF. They're still going to solicit to the collision center, and they're still going to get a bounty on this. So I agree this is a great start, and we have to start somewhere. Is this wording hopefully going to open up get some attention, get their eyes open, and then see where it goes? And I don't know, James Spears may want to add on this, but I still think it's going to solicit. even like Ken brought up the repair order that they carry in their truck. I mean, I still see that as a piece. It's just going to go to the storage lot first. I've heard the complaints here around us from people that they're going to the storage facility just so they get that transfer tow, and then they're going to the collision center that they want to take it to. So I know we got to start somewhere, and pardon me for rambling, but ideas, thoughts?
And again, we need to, and I understand 100% what you're saying, and I agree with it. But this rule is about our tow licensees. If we want to do something with regards to what is happening at the VSFs, we would do it in a VSF rule. This is just step one in us addressing flipping.
I understand, and it's a great start. Okay, board members, anybody else have anything to input?
This is Charlie Rash. I like the rule, but again, we need to add the VSF to the agenda so we can deal with this on their end, because it's just going to continue when you give the option of refusing to go to take the car to their location. You're just open. It's wide open for fraud still.
Sure, and something that we also need to keep in mind is that on this rule, it's not necessarily the end of the road. I was a little remiss when I went through sort of the process. What happens here is this is step one in the rule process. If you decide to make some changes today and decide to authorize publication, we go to a 30-day public comment period. And that is an excellent place for board members and for other members of the industry to go in and get to make some comments similar to those that you're making, and also any different ones if they have them. What we do is we gather all of those comments up, we bring them back to the board, we inform the board of what those comments were, and we decide at that point if it's ready to go to the commission. So the discussion about going over to the VSF side of the rules will continue as this rule process goes on. So rest assured that we will not forget it. It'll not kind of get slipped under the rug. We're well aware, and you all have made great points today, that we cannot stop here, that it's not just a problem on this side of the tow VSF industry, it's a problem on both sides of the tow VSF industry. And so we certainly will take all of those comments and look at those comments. And the other thing to remember too is once we get those comments in, if those comments reflect some additional changes that need to be made to the rules before it's sent on to the commission, that's when the board will decide whether they want to make those additional changes. So there is plenty of time for you all to look at the rule, and for the public to look at the rule, and for us to get a little bit of a step back to decide before we send it on to the commission, are we sure that it says exactly what we want it to say?
Tasha Moore, Elizabeth, that's great information. Just getting some guidance, because clearly the concern is making sure that the VSF side of that is addressed. And so getting some information from you on how to navigate, and so that we do work our way for a companion rule for the VSF to address this issue is great. Thank you for clarifying that for us. That helped me.
Yes, and rules are, as you all know, rule making is a kind of a long, drawn out process. So for those who haven't been involved in it, it can be a little bit intimidating. But we just take it step by step and we go through it. I think Todd Forrester may want to say something. I just got a message from him. Todd, did you want to chime in here on the VSF side?
Yeah, a couple things. Amy, one of the reasons that we did want to give the tow operators some kind of autonomy is you can run into a time where the person may want the car towed to another city or something. Not allowing them to refuse that could put that tow company in a bad spot, you know. As far as the VSF rules are concerned, we'd absolutely want to look at them. We do currently have in 85.710B, they can't, a VSF can't make a non-consent storage, a consent storage, a non-consent tow, consent tow, or consent tow, non-consent tow. They can't switch them back and forth. While it may not address the questions completely or as fully as we like, we do have something for it right now. Okay. And I'm pretty sure that Michael enforces that.
Right, and just to make it, just to bounce off of what Todd is saying, we very much were aware of a badly written rule could potentially put our tow folks in a bad situation if a consumer has an accident in Dallas and wants it taken to McAllen. Right? That could be a very bad situation if our rules did not address the ability of a driver to say, no, I cannot do that. But what I can do is take it to a licensed vehicle storage facility. So we're doing two things in that portion of the rule, which is empowering our licensees to make the decision of whether they do or don't want to do that. And we are also reiterating that if you don't want to do it, which is fine, we still need to go back to a licensed VSF. And again, what Todd is saying is there is some protection over on the VSF side. Could it be broader? We can definitely look at that and see and address the concerns that the board is raising today.
I understand. And again, you're going to have bad players in everything. We all understand that. But from complaints I'm hearing, when a customer wants to go to a specific collision center and the tow truck driver doesn't get a bounty from that, he takes it to a storage lot, so he has one more opportunity. But I get it. I mean, nothing's perfect. And so we have to work through this one step at a time. I think James is his mic unmuted. Do you want to chime in here, Mr. Spears?
I was just going to say that in your earlier comments, I agreed with your assessment that there could be some manipulation. So yeah, I believe you were spot on.
Do either of you have an idea for how to change that? Maybe.
I do believe if we next look at the VSF, I think that we can help to close that. So this is a great first step. It's going to be probably like a 1-2.
Yeah, I think we definitely have to look at the VSF side as well.
And because this is such a complicated problem, I think people from who are outside the industry probably don't understand. And Mr. Spears, certainly being on the insurance side, does understand how complicated this problem really is and how many people it involves and how many industries it impacts. So getting a one shot at a rule is not going to get us to where we need. This is a multi-step and multi-prong approach, and TDLR uses that approach across its programs to ensure that we are adequately addressing any problems that are being raised. And so because the first thing that we were tasked with was find a way to address this on the tow side, we've done that, and we will certainly move on to we've heard the board loud and clear, we need to move on to the VSF, and that would be our second step. For right now, we're just doing what Sunset wanted us to do and what the board wanted us to do, and focusing in on fighting the problem where it starts. It doesn't stop there, but it starts there.
And Amy, if I can, Tasha Mora, clearly I have a lot of interest in consumer complaints and what creates a consumer complaints and what's driving that. What I also see is for us not to be surprised that if this rule goes into effect, and so we do see that tow operators are declining to take a vehicle anywhere other than where they had wanted, perhaps, but ultimately declining to take a vehicle where the consumer wants, because they have that ability and authorization now. I could see where perhaps consumer complaints might spike for that area of, the tow company will not take the vehicle where I asked them to go. They refused, declined. They took it to the VSF. And I know that's going to be another VSF issue. But I'm already forward thinking, okay, so now perhaps the level of complaints against tow companies will increase, but then it gives an opportunity to find out why. Why are these declinations happening? What is the reason for it? But just kind of as the board, knowing that there's a potential for those numbers to go up, but we can use that information. And it's how do we use that information?
That's a strong point. I think Michael took himself off mute. So do you want to say something, Michael?
Existing law gives the tow truck operator the right to decline to take the vehicle where the vehicle owner wants it to be taken. What this law or this rule would do is then not allow him or her to say, but I know a really good place it could be taken. And so the reasons Elizabeth articulated very nicely, tow truck drivers can decline to take a vehicle to where the consumer wants the vehicle to be taken. The next step in the whole fraud scheme, though, is say, I can't take it there. I'm not going to take it there. You shouldn't have it taken there. And so we're not changing existing law by giving the tow truck operator the authority to decline to take a vehicle somewhere.
Right. And the rule has always said, as Michael stated, the rule has always said you can't take it to a place other than a licensed vehicle storage facility. We're just expanding it and prohibiting that solicitate. We're putting in that anti-solicitation language and clarifying that you are still empowered to say no. If you say no, though, the only place it's going to go is that VSF, and you are prohibited from providing any recommendations or solicitations.
Okay. Again, I just hope everybody's listening and understands, you're taking advantage. These companies that are doing this are taking advantage of consumers, which also down the road affects consumers because this directly impacts insurance costs and all of us down the road. And it's a huge topic for me. It's very close to my heart because I've seen it. I've heard it. I mean, I've heard plenty. Those of us in the Houston area, I know it's huge for us. Ken's over there shaking his head. I can't believe we've gotten this far and it's getting to the next step and Michael's going to leave us at this time. I just can't believe it. And he's done so much work on all this.
Well, and I actually would like to, I would be remiss to not recognize Michael because Michael has been a champion for the past 2.5 to 3 years of us needing a rule. And it is because of his hard work on the enforcement side that Sunset recognized the need for this rule. And so there are many people in the department, Tony Reed as well, who's also on the enforcement team, have all worked very hard on anti-flipping measures within TDLR. This is our next step to combating that. And Michael leaves a good base for us to bounce off of to go even farther in the future to really help stop this from being such a big problem in Texas.
Yes, ma'am. Okay, so we've got a word change I think Ken brought to the table. Do we want to move forward with that with a motion in a second, or do we feel as a board that we need more discussion? I mean, sounds to me like we need to go a second step with a VSF rule. I think this one's pretty tight, maybe with the word changing, unless there's other comments.
I'll make a motion to accept this with the word changes that we've discussed. And then to move forward with the looking at VSF at a later date, or does that need to be two separate motions?
That would probably need to be two separate motions. Okay. I'll defer to Mary on that. But let's just be clear on what language changes you're proposing, so everybody's on the same page. On B, we would put the word and in C, we would clarify in the second line the tow ticket must not include authorization. Those are the two words that you would like added.
Right. So are we going to take C out and make B all that? Or are we going to leave C in there and just put the word and?
That's right. The structure would stay the same. We would add the word and the word ticket. We would add the word and to the end of B and the word ticket to C, to the second line of C.
Okay. That's my motion.
All right.
I Tasha Mora, second that motion.
Okay. So
I'm sorry. Can we get a clarification? Are you moving to publish the rule with amendments as discussed? Mr.
Yes. Yes.
Okay, can you say that for the record, please?
I am moving to publish the rule with the changes we've discussed.
Tasha?
And I, Tasha Mora, second that motion.
Okay, we have a motion and we have a second. Do we have any more discussion from the board? Okay, motion carries.
Ma'am, we need to do a roll call vote.
Yes, ma'am. I always forget that part. Go ahead.
Thomas Griffin.
Aye.
Kyle Jackson.
Sorry, aye.
James Spears.
Aye.
Tasha Mora.
Aye.
Harry Hoffman.
Aye.
Charles Rash. And Ken Ulmer.
Aye.
And the presiding officer, Amy Milstead.
Aye.
Motion passes, ma'am.
Yay. Okay. Finally. Thank you. And so Elizabeth, are you still with us? Do we just bring up the VSF rule when it comes to new agenda items? You're on mute.
Sorry. Yes, that would be the appropriate place to do that.
Perfect. Okay, I've got it in my notes. Okay, so that brings us to agenda item G. We are all eager to hear from the Education and Examination Work Group, and I think Elizabeth has that topic. You're still on mute.
Sorry. I'm sorry. I'm getting a lot of messages from people within TDLR who are very happy at this rule move to publish. Thank you to the board. Thank you to everyone in TDLR. There were a lot of people who worked on this, you guys. It was a brain trust challenge. And so we're very excited. We are anxious to see what the public comments are on that. And let's move on to our work group report. So the work group met on October 12th. There were 3 board members who were present. 1 was absent. And there were 5 TDLR staff, including myself, the director of E&E, Ray Pizarro, and E&E staff, Lorraine Saruf, Angela Smith, and Cecilia Mojica. And so as we discussed at the last advisory board meeting, the work group in this particular work group is focusing on current CE requirements that are found in 16 Texas Administrative Code, section 86.250, which is titled License Requirements, Towing Operator Continuing Education. And this work group is tasked with 2 things: looking at that rule and determining whether changes to the current requirements are necessary. And if changes are necessary, we will look at whether a rule amendment is required. Depending on what the changes are, we may have to go to a rule amendment. So the group reviewed our current CE offerings and the requirements of the rule. And we focused on content as it related to 3 main concerns that were brought by our board members, which are reducing fatalities among IM tow operators, and us also understanding the inherent dangers of conducting roadside tows, a perceived disparity in CE topics relating to heavy-duty tow operators as opposed to light-duty tow operators, and safe towing of vehicles with new technology. I learned something new during this work group. I didn't actually know that sometimes when new technologically advanced cars come on the road and they are involved in an accident or need to be towed, there can be questions about the safety of those tows because the new technology has not been quite understood enough by the tow industry to know how to do it safely. I didn't even know that that was an issue. So I learned some very important things during this work group. And so I thank all of the board members for bringing up these and focusing us on what their concerns are. So some of the things that we talked about are, first and foremost, the current subjects that CE must currently cover do in fact encompass classes on the 3 topics that I just referenced. So E&E clarified, Ray clarified that if CE providers do want to provide courses that are specific to those topics, they can 100% do so. But licensees have a responsibility to be requesting those topics from the CE providers, because TDLR as a regulatory body does not mandate specific courses outside of the broad topics that are already outlined in the rule that are bulleted out in 86.250. So if you want to see specific topics, any specific CE topics, you really need to be reaching out to your CE providers to see if those topics fall under the broad categories in 86.250. And if they do, you can certainly request that those providers provide that training. Now, one thing to point out, though, is that the CE providers will have to come to TDLR to get authorization to provide anything that is beyond what they've already are already authorized to provide. But E&E is always available to assist our CE providers in obtaining approval for additional CE classes for which they're receiving requests. So when the group met, we looked at that and we said, okay, the broad categories as outlined in 86.250 allow licensees to ask for and CE providers to provide, with approval from TDLR, CE topics that relate to those categories. So there was nothing that needed to be tweaked in order to get those CE topics on deck. The next thing that we talked about is that as we began to have further conversations and really drill down on what the main area of concerns are, it came out that really the main area of concern seems to be with CE for IM licensees, given the inherent danger associated with those particular types of tows. So the work group decided that it's going to focus its efforts on amending the portions of the rule that relate to IMTO CE. And the board members offered some specific ideas on how to amend the rule, which we are internally exploring and not quite ready to talk about yet because we have some technological questions about whether it's even possible to do some of the suggestions that were brought forward. We will likely reconvene for a second work group in early 2021. And at that time, I hope to have some clarity for the board members who are in the work group on specific technology issues and how that may impact our options for amending any CE requirements for IMTOs. So that is kind of a broad overview of what we talked about, and I'm happy to answer any questions that you might have.
Any questions? That is a lot to take in, and I appreciate the work groups helping that and bringing everything to the table. So it looks like we have more work to do from what I'm understanding.
Yes, the work group is an ongoing endeavor, and I do imagine we will have quite a few more meetings before we actually look and say to ourselves, are we required to do a rule amendment? And if so, what would that rule amendment look like? So this is looking down. We are projecting down into 2021 and possibly 2022, but we're going to move as quick as we can. Keep in mind, legislative session is starting in January, and so what might have been a quicker work group will probably be extended out because our focus is going to be moved towards the legislative session.
Okay. Well, I know this topic came up at our last meeting because there were some concerns. Is the board satisfied with where we're at so far and moving to the next step? Everybody good? See heads, yeah. Tasha, Ken, y'all are good with the work group?
Yes. Yes.
Okay. Well, Elizabeth, thank you very much for that clarification, and we look forward to the next step.
Of course.
Okay. I guess that brings us to our item H, agenda item H, discussion explanation, federally mandated unified carrier registration and its intersection with the Texas Occupation Code, Chapter 2308, Vehicle Towing and Booting Act. Ms. Elizabeth?
Yes. So I'm not going to spend a lot of time laboriously explaining a federal mandate because this particular mandate is very lengthy. It is very burdensome to read, quite honestly, and it's difficult to understand. But I will give you the high points for what I think are some of the concerns, and you're more than free to comment and ask any questions. So why this has come up is because there have been concerns raised specifically about the ability of out-of-state tow truck operators to come into the state of Texas and conduct tows during hurricanes, more specifically, or natural disasters. And so this has been an ongoing concern that's been raised by past members of the board. And I think maybe there might be some current members of the board who have this concern as well. And several comments, I think, have been, we had a public comment that was received last time where a letter to the governor was sent addressing this and asking, why is this allowed? Why are out-of-state tow truck drivers allowed to come in when our in-staters have to be subjected to TDLR regulatory oversight and licensure? So the answer is because there is a federal act called the Unified Carrier Registration Act, or it's referred to as the UCR. And what it is it's a federally mandated system for registering operators of commercial vehicles who are involved in interstate and international travel. So they're going across state borders or across international borders to the north or to the south. The UCR requires motor carriers, motor private carriers, freight forwarders, leasing companies, and brokers who are based in the US, Canada, Mexico, or any other country that operates in interstate or international commerce in the United States to register. Because it is a federal mandate, it's a federal act, it preempts any state law which may otherwise apply to these carriers. That becomes very important in this conversation because we have historically interpreted and we continue to interpret the federal mandate to contain an explicit prohibition on requiring tow licensure of vehicles that have a required UCR registration. The required UCR registration is found in 49 United States Code 14504 AC, which essentially states that state licensure of UCR registered vehicles is, quote, an unreasonable burden on commerce. For those who might be familiar with the concept of interstate commerce and the Interstate Commerce Clause, which is covered in the Constitution, that is what it's referred to. In the United States, we have laws that prohibit states from enacting legislation that would effectively chill or stop interstate commerce. So the federal mandate here basically says if you have a UCR registration, which by the way, you're required to have if you're engaged in interstate or international commerce in the US, states cannot say to you, you also have to be licensed in the state that you're coming into in order to conduct business in that state. So in addition to that, 49 USC 14506C also includes a prohibition against state requirements on interstate motor carriers, motor private carriers of property, freight forwarders, or leasing companies to display any credentials in or on a commercial motor vehicle. So what that means is that when a vehicle has a UCR registration, they don't have to have any markings, they don't have to have any decals. And in fact, we researched this a couple of months ago, and DMV actually has a section on their website that says the folks that have that designation don't have to carry any identification which denotes that registration when they're in the state of Texas. So they can assert that they are UCR registered, and we have to sort of take that as face value. So what does that mean for TDLR? Well, as I said earlier, this act is a federal law which preempts state law. So the state does not have any authority to pass a statute or rules that would require out-of-state trucks to be licensed here in Texas in order to come within our borders and to conduct business. So per the federal mandate, if a tow truck with a UCR registration enters the state to do business, which would include towing cars for any reason, either within Texas or from Texas to another state, they are exempt from licensure requirements that are applied to tow trucks who only conduct intrastate business. So TDLR has provided in the past and continues to provide guidance to VSFs who are releasing vehicles to a tow truck operator who's working under a UCR registration or designation. And what we have advised in the past is what we will continue to advise, which is the requirements for release of vehicles under 16 Texas Administrative Code 85710 are the same for tow trucks licensed under TDLR as they are for tow trucks operating under a UCR registration. So if a tow truck operator presents payment of all fees, a valid identification, which can be either a Texas driver's license or other state or federally issued photo identification, and an instrument of release, the VSF is required to release that vehicle. Now, we've had people say, well, how do we know that this is on the up and up and this is legit and they have the ability to do this? What our response has been and continues to be is if a licensee, if it's a VSF owner suspects that a tow truck is not properly registered under UCR or is not properly licensed, they should refer that to TDLR as a complaint. They cannot refuse to release a vehicle when the requirements under 16 Texas Administrative Code 85710 are otherwise met. So that is kind of my 101 primer on UCR and how it intersects with our obligations as VSF licensees to release vehicles. And I'm happy to take any questions that anyone on the board may have.
I have a couple, Elizabeth.
Yes.
So does this essentially mean we're going to throw out all the emergency towing operators, the filing and everything else for emergency tow operators?
The emergency tow operations, as I understand it, are still in effect. We can still execute those things without coming into violation of the act. So there are certain things that TDLR still has that will allow people to operate under an emergency. Todd is actually more familiar with the emergency. So I am going to turn that over to him to see if he can address that more fully.
Yeah, so Ken, UCR is a separate designation under USDOT. You might have a company that's USDOT but does not participate in the UCR program. Those USDOT companies would still need the emergency license because they're not registered as UCR.
But if the company just says the words, we are UCR, then we are not allowed to ask them for any documentation and we just accept that whether they have a TDLR. I mean, essentially what the position that I'm being put in to avoid violations. And we all know that, Copart filed a whole bunch of complaints because their guys were not licensed under the Emergency Act, and they should have been. And I personally witnessed that myself. We're in a position where my reaction to this and my only solution to my employees is to say we no longer ask for anything other than a driver's license and a VSF when a tow truck company comes to pick up a vehicle. I mean, that is really the only action that we can take at this point in time and be compliant, because the way I'm understanding it, we are, if they just say the word UCR, and how would I prove they did or did not say that? So if they claim they did after they leave because somebody coaches them and says, oh, you should have said you were UCR, then I'm going to have a complaint. So,
well, right. But Ken, you're also going to have an instrument of release.
Right. That's what I was going to point out, Ken, is we aren't focused on UCR designation, not UCR designation. What we're focused on is, do they meet the requirements under the rule for release? If they meet the requirements for the rule under release, regardless of whether somebody is licensed in Texas, not licensed in Texas, you have to release the vehicle. If you suspect that there is non-licensed vehicles operating within the state of Texas who need to be reported to TDLR, send them our way. We will look into that and we'll address it. But the responsibilities on the VSFs laid out in the rule is if a tow operator meets the requirements under that rule, it has to be released.
So by meets the requirements.
So you got to have payment, valid state or federally issued ID, and one of the instruments of release at 85-710, A3.
So stop asking if you have a tow truck license, or stop asking any of that. If they present us with a valid VSF, a driver's license, and the payment, we will just release the vehicle.
That's your responsibility. Correct. There are things that may not be tow trucks by definition that may look just like a regular tow truck. For example, a rental car used only to tow rental vehicles. Budget rental car has a rollback tow truck, but by definition, it's not a tow truck.
I have a question. This is Tasha Mora. So should an individual present themselves at a vehicle storage facility and they have this UCR designation or claim to have it, they provide documents and payment, then a VSF would proceed with the release of the vehicle. So the individual listed would be able to gain access to our licensed vehicle storage facility to remove the vehicle. However, perhaps they would not be allowed to allow the vehicle that they're bringing in to enter that licensed vehicle storage facility.
Right. So
if I can just, because if we were releasing to a vehicle owner or operator, we do release to that vehicle owner or operator, and that vehicle owner or operator enters usually by foot into the vehicle storage facility to get into their vehicle and drive the vehicle out. So we would be able to release the vehicle to the individual who presents themselves at the VSF, but would we have the authority to decline access of this vehicle that the person's driving into our vehicle storage facility? Do we have that authority?
Yes, you're never required. Nothing in our laws and rules require you to allow any vehicle on your lot. Your insurance policy may prohibit it, but you got to make sure they get the vehicle. The vehicle's not released until they get it. We're not saying, even because, again, your insurance policy may prohibit any other vehicles on there so they don't hit other cars on your lot, whatever. That's fine. We're not saying you have to let somebody on your lot. What we're saying is you got to make sure they get the vehicle. However you want to do that. You want to pull it out for them, you're more than welcome to do that. I understand what you're saying. Okay. You can still meet the requirements of the rule.
And then my follow-up question to that is, if we release the vehicle to the individual, and so then the next step is making sure the vehicle is physically released from the facility, could a VSF then allow another licensed tow company to come in and remove the vehicle. If they want to hire a secondary licensed tow company to come into our vehicle storage facility to remove the vehicle for them, then that's their choice.
Right. So like if I come to get a car off your lot and I hire a different towing company.
Right.
I'm allowed to do that. And you're allowed to let that person on your lot.
Okay.
As long as they're licensed. Yeah, you don't have to, but you got to make sure they get the vehicle. Again,
Right.
you have to make sure they get the vehicle.
Right. Because my concern is, of course, allowing anyone without proper credentials into our licensed facilities, that they cause damage to other vehicles that we have stored,
right,
is making sure there's the credentials there to be able to track that down and hold that company accountable, you know?
Understand.
Right. Tasha, our rules don't speak to that, I think is the bottom line. So whatever you need to do as a business to protect yourself as a business is a business decision that TDLR does not involve itself in. But with regards to the release of the vehicle, it has to be done. So however you want to affect that release is your right as a business owner to make those decisions. We don't have any rules that relate to that. What our point is, again, is that if they meet the standards, the requirements under the rule for release of the vehicle, regardless of whether they're UCR, not UCR, licensed, not licensed, because let's be honest, we have people here in Texas who are not licensed and they're picking up vehicles at VSFs, and our folks catch them doing that. What we are focused on is the rules that say if these things, then the release must occur.
Understood.
And if you have complaints or concerns, we are happy to receive those and look into them, and our enforcement unit will take those and do what they need to do.
Understood. Okay.
And let me just say, if I could just say something, Elizabeth, and I don't get me wrong, because I have all the respect in the world for Todd Forrester. He does a lot for this industry, but I dislike his wording on we must make sure they get the vehicle, because we currently have lots of situations where an owner comes in here and goes, oh, I didn't know my car didn't have 4 tires and wheels because it was stolen. And we go, well, I'm sorry, but that's the way it is. And they go, well, what do you want me to do? And we tell them, well, I guess you got to call a towing company. I mean, we don't do anything with that. So they may have released it, paid the fees, and then not be able to get it. But how would we make sure that they're able to get that? Because I'm not going to put tires and wheels on it for them. It's sitting on the ground. So I leave it in their ballpark. I go, hey, you've got to make some arrangements to do that. And I will tell you, 25, 29 times last year, maybe 30, because we keep track of it. People didn't even pick up that car after that fact. They said, you know what, it's not worth it, or I'm not going to get it. And we had to then deal with that car and put it through our auction process in the city of Houston, even though it had been paid for, and they just decided they didn't want it after they saw it, or whatever the case may be. So that is where you kind of get into a situation. And I just had one recently where somebody came in with a tow dolly and said, well, I can't get the car on the tow dolly. Well, I mean, I'm sorry. What do you want me to do? I mean, I can't put it on there for you.
So let me clarify, and I think there may be some misunderstanding possibly of what Todd said based on what your statement is. What we as an agency are saying is if those 3 instruments of release are presented, the vehicle has to be allowed to leave the lot. I'm distinguishing that from the situations that you're talking about where a consumer may come in and go, well, I can't do it. I can't because it doesn't have wheels. I can't because it doesn't fit on a tow dolly. That is completely different. You have given them the opportunity to remove it, and they have made a decision as a consumer not to remove it. So that is a different situation from what we're talking about with a tow operator coming in, presenting you with the things required under the rule, and you saying, okay, you can take it, right? Whatever they need to do to take it is whatever they need to do to take it. If they decide not to take it, you've still complied with the rule. You gave them an opportunity to take it.
I think the problem comes in when they go, oh, okay, well, I'm just going to hook up a chain and I'm going to tow it. Things of that nature that occur. And they occur pretty frequently when people want to do that, regardless of how safe it is or how legal it is to tow it with a chain. And typically, most VSFs, us included, don't let them do that. I mean, we can't allow that vehicle to come in our VSF and, hit other cars, do whatever. because we're responsible for those cars. So, I mean, we're really getting into a catch-22 here. My second thought is, when did this UCR thing come up? After this letter was written to the governor and someone researched it?
The questions about UCR have been circulating TDLR periodically. I've been here 4 years now. It's been a conversation for the entire time that I've been here. And I think it started way before. Because I remember Charles Johnson, who was the GC on this program before I was. When I inherited the program, I remember attending meetings that had well been in progress on this subject. And so TDLR has a history of saying, a lengthy history of interpreting that mandate to say, we cannot require these out-of-state folks to be licensed because of the UCR mandate, because it preempts state law. And that's just a matter of law. Federal law is higher than state law is higher than municipal law. And so that's where that preemption comes in. So really, quite honestly, Ken, I think the concerns here should be directed towards your senators and your congresspeople, because they're the ones that have the power to do anything about the federal mandate. Unfortunately, not TDLR.
Okay.
I got a question tied to that, Gary Hoffman. And I'm looking at this from the tow side, but if they're allowed to come in under the UCR regulation and pick vehicles up, what's to say us as a Texas tow company, if we, like I have a UCR for my trucks, why do we need TDLR licensing if the federal license supersedes it? Why do we need TDLR licenses? Can we not just have all our tow trucks on the UCR and we can tow within Texas or out of Texas? It doesn't matter.
If you are solely towing within the borders of Texas, you are involved in intrastate towing, and that requires state licensure.
And the exemption only covers, it doesn't cover non-consent towing.
Right.
The federal law is very specific.
Mm-hmm.
And the federal law does not cover non-consent towing. That's what you're saying. So, but all consent tows would be fine with it.
Correct. The federal law says that we can license and regulate non-consensual towing.
That's right.
Okay.
So there's two things to consider. Are you operating within the borders of the state, in which case you're solely intrastate, and the point that Todd just raised?
But as far as the intrastate, though, I mean, if you do one call every 2 months out of state, you're still interstate instead of intrastate, correct?
That would be my understanding, but because UCR is a federal animal, and I'm not, I haven't done that deep of a dive into the federal act. I've done enough to know what the act says and how to advise the agency on it. I would not be comfortable saying for 100% that is correct.
But it's okay, like for somebody from Oklahoma to come into Texas and tow Texas to Texas, or Louisiana, Texas to Texas.
Yeah, Gary, and that's very.
I think the answer is yes.
Those are very specific situations too, and they depend on federal law as a continuation policy. It depends on all that. Again, Elizabeth and I aren't experts in USDOT. You would have to check with them. The key thing is if you're doing non-consent towing, point to point within the state of Texas, you need to get a license through us.
Okay, thank you.
My question is, does Texas TDLR have jurisdictions over these out-of-state companies that come in with their UCR? So they're breaking the rules or they don't actually have it. Do you guys have jurisdiction to penalize them?
Jurisdiction would be dependent on a fact-specific pattern, and I can't answer that question without having a specific fact pattern in front of me.
Thank you. Charles, you're on mute. Are you talking to us?
Yeah. Can you hear me now?
Yep.
One problem I see is when an out-of-state company uses a VSF 011, it doesn't say where the car is going to go, especially during a hurricane situation. We get hundreds of cars. They come in with VSF 011s from different insurance companies. We don't know where these cars are going to go. And we can't really direct the owner of the car or where their car is. And the companies are not in the state. So it's very hard to track your car down after it's picked up. So really we need to address the VSF 011 and put, mandate where the car, you have to list where the car is going to be taken to. Because let's say somebody has a VSF 011 that was signed by Allstate and we don't know that it was taken to Copart, IAA, or a holding lot during a hurricane situation. We have no idea, and we have
So
no way
the
to direct it.
So I hear you and I understand your concerns, but the VSF Form 11 is not on the agenda for today. And we need to confine our discussion to what was properly noticed, which was discussion of the UCR. I understand what you're saying about the intersection, but that is a separate issue that has also been discussed extensively over the years within TDLR, and it's not on the agenda today.
Thank you, Charles. Any more discussion from the board on this? Can you just unmute it? You got anything?
No, I don't.
Disappointing, to say the least.
Disdain for this issue.
Yeah, definitely. Okay. If there's nothing else on that matter, Elizabeth, I guess we move forward. This is where you guys bring it up. Recommendations for agenda items for the next board meeting. Let's lay it out there and get it on the record.
Amy.
Yes.
I'd like to put the VSF 11 on the next agenda.
Okay, Anna, you got that? I want to bring up the VSF rule for flipping to protect us there.
Yeah, we can do that. It really depends on timing on when the next one is. And I spoke with Mary yesterday about timing. That's something that I think Mary can address more fully, because I think we're kind of unsure of when the next one would be. But yes, if you want to put it on the slate of things for us to consider putting on the agenda, that's fine, the rule.
Perfect, thank you.
I would like to make a recommendation for a future agenda item, hopefully the next board meeting, to discuss and explore, I don't know the proper wording, but the costs related to credit card fees. And I think that's something that we need to explore. And a big issue that came up at the training meeting that Todd hosted yesterday, or Todd presented yesterday. I believe there's a misunderstanding of the costs involved, and I would like to be able to explore that and present some numbers and things of that nature. We need to get it on the agenda to do that.
Okay.
Amy, you had raised a question that we wanted to ask more specifically about the issue of light duty and heavy duty. We have discussions that we don't really understand what you would want on an agenda item concerning that. So can you please more fully explain that to us?
Yes, thank you for reminding me of that one. Several of the municipalities are having concerns because they don't understand the difference in the tow trucks. They don't understand a light duty versus a heavy duty. There is nothing nationally that describes or explains the difference in the tow trucks. So we are wondering if that's something that Texas can take a look at, TDLR, to put something in writing. And I don't even know where that starts, if that's legislation or if that's something here, but they're asking for this. I've had numerous requests, and where do we go from here?
Okay, I'm just trying to understand what the issue is. So are you saying, because my understanding is that there are some definitions in statute on, so I'm a little confused. What exactly is being asked?
What we found in statute is only the definite, or maybe I'm speaking wrong on that. The only definition that we've been able to find anywhere, and I know Ken can chime into this, is the definition of a private property tow and what sizes a private property tows, and that breaks down the price points. But we haven't been able to find anything anywhere. Ken, are you up to speed on this conversation and all of that? Okay, I haven't seen anything, and everyone I've researched this with, there's nothing.
That's all we have. So just for a little more clarification, how is the city involved in this? Is it because people are bringing out light duty records to heavy duty scenes? Like, what's happening?
Most definitely. Most definitely. They are towing unsafe vehicles with light duty equipment. And it's a very, very unsafe issue, not only for the tow operators, for the community, for the general public. It's very dangerous.
Okay.
Is it addressed in the ordinance?
No, and they say they can't touch it because there's no definition of a tow truck.
Of a light or heavy duty? Right.
Correct.
Okay.
Okay.
I think I get it.
I definitely have a better understanding of what the concerns are now. So we can look at that as a possible agenda item for next time. I see Mary's taking notes, nodding her head.
Sorry, Mary Winston, I was muted. Yes, got you now, Amy. We were trying to figure this one out, so that gives us some more context. Thank you.
Very much so.
Right, thank you. Gary, I see you're unmuted. Do you have something to add to the agenda
Yeah,
items?
just back on that I talked about earlier. I don't know that we need a lengthy discussion about it, but if I could get clarification on an answer. If a law enforcement is instructing you to drive like an oversized vehicle or an unusual type vehicle into your storage facility, I know if you're not towing, you can't charge a tow fee, but are there fees that can be charged, like a drive-away type fee or whatever?
I'll call you after this.
Okay, all right.
So does that mean we add it or it's pending?
I'm fine either way.
It seemed like Todd is seems pretty confident he could answer that question over the phone, needing to be an agenda item.
Okay.
Yes, I can.
Okay. Gary, that's all you have? Tasha,
Yes,
Ken, Charlie, anybody?
Nope.
No.
Okay. Anybody else have anything? All right, then I guess that takes us to discussion of date and time. How do we even set that knowing that we're fixing to go into session?
Yes, ma'am. So we are thinking of either late January or early February, depending on how long it'll take us to process the public comments that we're going to receive from the proposed rule. Would you like me to poll the board closer to that date?
That'd be great, and that's definitely much quicker than I thought it would be. So that's wonderful.
Okay.
Any objections to anybody on the board for January or February? Perfect. Time. David, did you have something?
So Chair Milstead, I just want, before you adjourn, I want to make sure and get this on the record because it's so important. Chair Milstead, advisory board members, David Gonzalez, Deputy Executive Director, Licensing Services. I just cannot let it go and mention that it's so refreshing to hear y'all's group's propensity to catch your industry doing things right. Y'all brought it up during the enforcement report so much. In fact, I want to add my own kudos to the program's online renewals and their online renewal percentages. A lot of our programs don't have that option. And so we appreciate the industry taking advantage of that option because it frees our licensing program staff to take care of those programs that don't have that option. But on the record, I want to thank y'all all for your volunteerism and remind our customers that your efforts shouldn't be taken for granted. The questions and the feedback that we received today was so phenomenal. And this meeting, in a word, was exemplary. In fact, we'll be having an after action review talking about how we want more engagement from our other advisory boards to this level. Y'all are representing your industry with flying colors, and y'all's participation makes our staff and our agency better. So I just wanted to thank you and put that on the record.
I think this board is extremely passionate about what we do, without a doubt.
No doubt.
Okay, so Anna, we're going to leave that in your hands for sending us some dates and times. Is there anything else that is on, do we need to discuss anything else? Okay, I need a motion to adjourn.
I'll make that motion. Ken Ulmer.
I need a second.
I'll second it, Gary Hoffman.
Okay, Anna, do you need to take a poll on that?
Sure. Thomas Griffin,
Aye.
Kyle Jackson. Oh, I'm sorry. Kyle Jackson left. He had a meeting at 12:30. James Spears,
Aye.
Tasha Mora,
Aye.
Gary Hoffman,
Aye.
Charlie Rash,
Aye.
Ken Ulmer,
Aye.
and Amy Milstead.
Aye, let's
Motion
go. All right, thanks everybody. We'll see you next time. Have a good day. Be safe.
Appreciate it.
Everyone.
Everyone
Thank you.
Aye.
Thank you all.